Gentlemen. My name is Frances McCleary and I'm the reporter appointed by ministers. Can I just, before I progress, does everybody that needs to see me and hear me, can everybody see me? I think the best way to indicate that is by the international symbol for good. Right, okay. So this is the pre-hearing meeting for an application under the Electricity Act 1989, Schedule 4, for a necessary Wayleave application by SB Transmission plc for a section of underground cable at land on the former Kincardine power station site, Kincardine, Alloa. And this is a pre-hearing meeting convened to discuss arrangements for the hearing itself. Does everybody who needs one have a copy of the agenda that was previously distributed for today's meeting? Well, I regret to say that after having prepared it, I've had at least 2 additional items, but mainly that's basically my plan for this meeting. We'll get round to these in a minute. So that introduction having been concluded, can I now take the appearances at today's meeting, please? Can I start with the applicants?
Good morning, ma'am. My name is Magdalena McLean. I'm a solicitor and partner of Shepherd and Wedderburn, and I'm joined today by Mr. Ewan McLeod, who's also a solicitor and partner of Shepherd and Wedderburn, and Ms. Zoe Rocks, who's the in-house solicitors with Scottish Power Energy Networks. And I'm also joined by Mr. Andrew Clarkson, who's the head of programme in Scottish Power Transmission, Mr. Ewan Bolthwick, who's the senior project manager, Ms. Fiona Ramage, who's the...
Hang on a wee second, Ms. McLean. Mr. Borthwick is?
Senior project manager.
Senior projects manager.
Ms. Fiona Ramage, who's the land officer, and Miss Catherine Barber, who's a trainee land officer. And their details and experience are set out in more detail in the rebuttal hearing statement, and in particular the appendix, which includes their summary CVs.
Right, I remember that. Right, Miss McLean, that's your team?
That's correct.
That's fine. Now, is everybody with you in the boardroom at the moment, or is anybody else?
Everybody's in the room with us.
Right, because I've got various people who are in various windows because they're dialing in. Right, thank you. Now, can I move to the landowners, please? Who's speaking for the landowners today?
Yes, ma'am. My name is Colin Hamilton, partner at Gillespie McAndrew, and I appear on behalf of the landowners, together with Monica Cannon, legal director at Gillespie McAndrew, who's seated to my right. To my left, we have Fergus Thompson, the surveyor of DM Hall. Apologies, Reggie. And to his left, we have Wallace Mingus, director at Tillicoultry Quarries. And to his left, Robert Hamilton, the production manager at Tillicoultry Quarries. And joining remotely are Nick Gallop, the director at Intermodality, and Damien Power, a chartered engineer and associate at Intermodality.
Okay, right. As I say, the layout on my screen is just a little confusing for me, but we'll see how we get on. Right, Mr. Hamilton, thank you very much. My first sort of point, I think, arises here, actually. My first additional point Is there anybody else who should really be involved in this matter? It struck me as I was reviewing the materials you submitted. The site is obviously a complex area. From, I think, perspective one would bring to this would be one of natural justice. Is there somebody whose representations, in your view, either of you, should be contacted by the DPA to see whether or not they wish to participate? That's out of left field. Neither of you were expecting it. You may, and it's a big, actually quite a big question. I've totally ambushed you on this point, and it's not one to be answered off the cuff. But I think from both your perspectives, given how you want matters to resolve one way or the other, it might be difficult if someone should have been a participant from the point of view of natural justice and was not involved. So I think what I'll do is leave that with both parties, and I'll pick it up in my note. So that's my first bombshell. The other one should be less problematic, I think, but I'll leave that with you. Is there anybody else who should be involved? Okay, reverting to the agenda, the second point under my item 2 was about whether or not the hearing should be in public, and this, I think this extends to today's meeting. As you recall, paragraph 7.2 of the 1967 procedure rules says the hearing shall take place in public unless the Electricity Authority or any objector requests the appointed person to hold it in private. So, what do you want to do? Do either of you want this to be public or private? I'll start with the applicants. Do you have a view?
The applicants are content for this meeting to be held in public, and for the most part are also content for the main sessions to be held in public, subject to the sensitive documents on which we've made separate submissions to the DPEA, which we think should remain private.
Right, for today, you're happy that we should carry on in public?
Yes.
But you have a mixed response to that for the hearing procedures when we finally get to them.
We think there is some content of some of the documents that should remain private, and it might be that that could be dealt with as part of the session where particular documents would only be discussed in private, or if the landowner preferred, so it could be held in private, in which case there would be no concern over the content of any of the documents.
Right, I thought you might have something along those lines to say. Complex thing logistically. Mr. Hamilton, public or private, what do the landowners consider? What's your view on whether these proceedings should be public or private?
The landowner's position is the proceedings should be in public.
Okay, well, that's fine. So today anyway, we're in public, and that's fine. We'll continue to have it webcast as we have made arrangements for. Okay, so we stay public. Now here's my next additional item. It's a preliminary matter, and I noted after preparing the agenda and when rereading the hearing statements that the landowners actually wish to object to the late lodging of the applicant's hearing statement. Can I check, does the landowner wish to maintain that objection? Mr. Hamilton, no? Yes?
Sorry, Matt, I had some technical difficulties there. No, the landowners content to withdraw that objection.
Okay, thank you. Good. Nice and neat. Thank you. Right. Thank you, Ms Hamilton. Now, item 3 on the agenda is my introduction to the statutory process. I'd like to go over the statutory process. You'll know it very well, but it's partly to give you a bit of an insight into my own approach to Wayleaves. It's basically what I'm doing is I'm explaining the legal criteria as I understand them to be and as I have used them previously, so that, and you can comment on that when we get an opportunity for that. So, as you know, the application tests are in paragraph 6.1 of Schedule 4 to the 1989 Act, where it says that a Wayleave may be granted where, for any purpose connected with the carrying on of the activities which he is authorised by his licence to carry on, it is necessary or expedient for a licence holder to install and keep installed an electric line on, under or over any land. So I would observe that these are alternative tests. It could be either necessary or expedient. I take the view that necessary means that the Wayleave is required in the context of the statutory framework of the Electricity Act 1989 and required at the location for which the application is made and no other place. There's some legal authority on the meaning of necessary derived from other legislation, and from that we derive the principle that the word necessary does not mean essential or indispensable, but instead means required in the circumstances of the case. Now, the word expedient, which is the alternative measure, has a slightly wider meaning than necessary. In respect of expediency, the term is generally regarded as meaning advantageous in all the circumstances, convenient and practical. So it's a slightly broader measure. Now, the law on any matter which is reported to them is always a matter for ministers. I do not advise ministers on the law. I'm outlining my understanding of the law, which will inform my investigations. So if you think a different approach should be taken to either of these criteria, or a point's being missed, a legal point's being missed, or insufficiently noted, you'll need to make submissions about that for onward transmission to ministers. Now, further observations, there are some matters which I consider will not be relevant to my investigations in my report, some of which I think I can see foreshadowed in the respective cases as presented thus far. The first one's matters relating to compensation, which both of you, in fact, have alluded to, even if not directly. And I take the view that any matters relating to compensation are not going to be relevant to the question of whether or not the application should be granted. This is all reserved to the Lands Tribunal for Scotland and so falls outside the scope of relevant matters. However, the financial impact of the application on the landowner may be relevant, although without any compensation being brought into consideration as a factor to be considered as part of the expediency test anyway. So I'm not ruling out money, it's just that it can't come anywhere near compensation. Secondly, conduct of the parties in prior negotiations. Now, it's interesting how often this emerges in Wayleaves. Both parties tend to be quite cross with each other by the time they come to a Wayleave application. But my remit is focused on the application, the outcome of the application's decision-making process, good or bad. And it's for the applicant to show ministers that the case is made for the application. I take the view that that means that the manner and conduct of any prior discussions between the parties are not relevant. I'm not going over old discussions, and I'm not going to consider the conduct of the parties during the dialogue that did not result in agreement. So it seems to me that some of the dissatisfaction of the landowner, if I may say so, and the responses to that dissatisfaction may well not be matters I would wish to include in my report. Now, if the landowner takes a different view, you would have to make some submissions to me that I would find sufficiently convincing to either take advice on them or take the view that they should be included. You see where I'm coming from on that, Mr. McLean? You understand what I'm saying?
Yes, that's all understood.
Yeah, Miss McLean, it's Mr. Hamilton, sorry. Mr. Hamilton, do you understand what I'm saying about that?
I understand what you're saying, ma'am. I think there may need to be a legal submission on that matter, however.
Right. Well, we'll sort of inch forward on that, because I may have to take a view on whether or not I'm going to hear passages of evidence, and that'll be something that might come up in the course of the proceedings. The third thing I wanted to make an observation about is alternatives. As I say above, the matter before ministers is this application and no other route, but both the necessity and expediency standards do include, in my view, demonstrating that it could not, alternatively should not be elsewhere. So alternative routes are relevant, I think. Procedure. As to procedure, the rules are the Electricity Compulsory Wayleaves Hearing Procedure Rules 1967, which was quite a while ago. They may even be older than quite a few of you. They do confer a wide procedural discretion on the reporter as regards the hearing process, and we use that discretion to base the procedure on more modern practice derived from planning appeals. And that, of course, includes the use of virtual tools during the process. So I'm not precisely going to play fast and loose with them. They stay there as our baseline, but we use what are now tried and tested procedural mechanisms derived from planning. Now, that's the preliminary points I wanted to leave with you, either legal or quasi-legal. Does anybody have any questions to raise or comments to make to me about my summary of the legal points I've just made? Anything they wish to say to me about what I've just mentioned? Everyone content so far, as it were? Okay. And moving on. Item 4 on my agenda is my summary of the key elements of the respective cases. Here I'd like to lay out a rather brutal summary of my broad understanding of the respective cases. The idea here is to show you how I've reached my current view on the matters I'll require to report on, my headings, as it were. My current identification of what will probably be the determining issues. So this is not the determining issues, this is my analysis of your cases. First of all, the applicants. Against the background of your obligations as a transmission licence holder under the 1989 Act, the application is for about 450 metres of Wayleave for a section of 275 kilovolts cable undergrounded to a proposed depth of 1.4 metres. It's to form a link between the existing Kincardine 275 kilovolt grid substation and the 5-grid 275 collector substation, which I don't think is either is constructed, but maybe approved. Am I right about that?
That's correct. It is approved, but it's not constructed.
Right. You cite the importance of the Kincardine Grid Services Complex, its importance and standing in Scottish Government policy, particularly the energy strategy, the networks vision, which are both phrases used by government, and NPF4, the National Planning Framework 4, relatively recently approved. You say the application route was chosen through a connection needs case and route options report, which assessed a combination of technical, economic and environmental considerations. In moving forward, you've taken account of the landowners' plans for the land affected by the Wayleave, relying on information taken from their planning applications. And you say that on the basis of that information, you have minimised the impact on the landowner. You note that the landowner's plans include the reactivation of railway lines, which you describe as disused, but you're confident that the line can be installed within the appropriate spatial clearances, etc., and need not prejudice the reactivation of the railway lines or any of the proposed uses you understand to be under consideration. You highlight that the subjects are currently crossed by lines for which there are servitudes, and that the impact would be comparable to that known about by the landowners at the time of their acquisition of the land. That's my selected highlights from your case. Applicants, is there any theme in your application case which I've not mentioned, which you think should be in our minds when we're planning the hearing? Have I missed anything that would need to be coloured out?
No, ma'am, that's a very fair summary. Okay,
right. Now, good. Right. Mr. Hamilton, I seem to be going to do something which is always happens at every hearing. I'm going to call you Mr. McLean. Apologise in advance. Mr. Hamilton, same thing. Here is what I understand to be the landowner's case. So you say that the necessity and expediency tests are not met. You say that the objectors' European Convention on Human Rights, Article 1 protocol in particular, have not been met in a reasonable and proportionate manner. You have plans for the site, and you say that there's an operational and locational need for these plans, and that they comply with local and national land use policy for the site. You intend to bring the rail link back into use, and you describe the environmental benefits which would arise from that. You say that the line and the Wayleave, if granted and installed, would act detrimentally on your intended uses and could effectively sterilise the land for 40 years, which I assume you mean for the duration of the Wayleave, is that correct? You describe how the line could prevent the location of the various facilities which you currently intend. You say that the cable under active railway lines with heavy wagons passing over means that there would be significant risks of structural failure with all the adverse consequences, both for yourselves and for the applicants. You say that the current proposals for the buried cable are non-compliant with the appropriate engineering standards and require significant redesign. You criticise the applicants, I think, mainly for no mention being made by anyone of these proposals at the time of acquisition. And I, as I've said earlier, have reservations about whether that might take us into irrelevant issues. And I hear you, I think you're not willing to drop it just yet. You say that the applicants have failed to consider reasonable alternatives, and you describe two options in particular with significant technical advantages and less impact, which you say the applicants have wrongly rejected. Now, that's my summary of your highlights, Mr. Hamilton. Is there any theme in your objection case which I've not mentioned, which you think should be in our minds as we plan the hearing? Have I missed out anything that we need to be thinking about as we're designing the concert?
I don't think so, ma'am. I think that's very fair summary.
Okay, good stuff. Right. Now, moving on to item 5 on my agenda, and this again is my analysis of the cases in terms of topics to see if we can identify and hopefully agree on themes for the hearing sessions, if we do have hearing sessions. First of all, I think it is plausible to organise the hearing under topics. So that's good. Not wholly convinced about this, as I'll explain later, but I think you could have topics. I have found it quite challenging to rationalise the matters into a reasonable number of headings that are kind of sufficiently broad as to take in the points that are made by both parties. So what I've got listed, and I think you've got a copy of it on the agenda, these are my identification of the things I need to inform ministers about rather than highlighting the disputes about the parties. So if you see, this is a completely different perspective from what I've just outlined. So to me, topics arising from the applicant's case would be the need for the line, the description of the proposed installed line and related apparatus, including location. I really want to know exactly what you propose. That may take me into an area where I really need quite significant technical detail. Timescales for construction as currently envisaged. And I appreciate that might be quite an ask, but we've got two conflicting plans here. I'd like to know what your timescales are, and I'd like to know the implications of the construction process. Topics arising from the landowner's case, the landowner's plans for the use of the land in the shorter and longer term. I'm going to advise ministers on impact. I need to know what tiliculture quarries want to do with their land. You're going to need to know about the permission processes which are yet to be passed. Actually, that could include proposals by both parties. Again, timescales for implementation, what we're tiliculture wanting, when we're tiliculture wanting to move forward. I want to know about the impact of the installation and the presence of the line on the use of the land in the short and the long term, and the alternative locations for the line. Now, don't misunderstand me. These are the topics. These are not to. I don't anticipate either party particularly to lead in either one, but I would like to work collectively to examine these topics. Okay, that was my go at it. Does anybody have any comments? You have seen my list of topics because they've been on the agenda. So first of all, the applicants, Ms. McLean, do you have any comments on my list of proposed topics?
No comments as such, and we think that that's a fair list of topics representing both parties' cases. From discussions with the landowners' agents, we understand that the need for the electric line might be capable of agreement in a statement of agreed matters, but I know that's later on your agenda.
Well,
so I'll come on to that.
Good. And I'm not surprised that's a possibility. That's good to hear. Although there is, of course, the question of necessity. That might become a very spatial aspect of it, mightn't it?
Yes.
Yeah. Okay. Right. Anything to add, Ms. McLean? I interrupted you.
No, nothing further.
Right. Mr. Hamilton, what do you think?
Thank you, ma'am. Again, we're content with the topics in the agenda. We think they're fair. Ms. McLean is right that the need in the sense of the electricity framework need is likely to be a matter of agreement, but of course the location that is to be and that is necessary for that line to take is a matter hotly disputed.
Okay, right, okay. But my topics work for you, Mr. Hamilton, basically.
Yes, ma'am.
Well, phew. Right, okay. Now, item 6, and this is quite a difficult one. I don't think this is a straightforward case that falls neatly into something that could be effectively examined by me in written submissions. But between hearings and public inquiry procedure, I think it's quite a difficult choice. Let me go over the options. First of all, we could have written submissions where everything was in writing and there was no oral submissions. I just think there's too many quite difficult questions that need to be examined for that. So I'm not suggesting that to you. You would have to agree to that anyway, but I don't think that would be sufficient. And then there's a hearing procedure. And as you know, that's a structured discussion led by the reporter. Cross-examination is not usually allowed, but you can have direct questioning, and concluding submissions are optional. So I do all the prior work. I'd know where I needed information. I'd ask questions and we would initiate a discussion. I am not confident that that really is the most effective mechanism for me. Public inquiry, recognitions, cross-examination, concluding submissions. Everyone assumes that they're large and unwieldy procedures. They need not necessarily be. I have to say that having reviewed the hearing statements, particularly about the technical aspects, I'm worried about whether a hearing format will be sufficient. And I haven't made up my mind as to whether or not I should structure this around a form of public inquiry procedure. So I'm going to have a think about that. My concerns are the Donald Rumsfeld principle, the unknown unknowns. I don't know what I don't know. And I expect some of the key questions to have a technical basis. And as I'm not an engineer, I have reservations about whether I'd be able to lead the discussion without missing key points. So I'm strongly inclined, whether we go for a hearing or whether we go for a public inquiry, to include some form of cross-examination, direct questioning. It's still one of the best ways to test evidence where it's heavily contested. So I'm thinking about a hybrid hearing procedure focusing on particular issues with public inquiry elements such as pre-prepared recognitions for witnesses and cross-examination. Real mixture. I'll make it all clear. So that's my confused picture so far. What do the parties think? Ms. McLean, what do you think we should be doing?
The applicant recognises that there is a considerable amount of technical detail which relates to the routing of the line. However, we consider that it would be more productive if parties were able to discuss these through a structured form of a hearing in a collaborative and discursive format rather than through an inquiry, as a discussion would lend itself to clarifying some of the key points, with both parties having the opportunity to comment on specific issues which might come up. And the hearing could be structured around the topics which you have identified and around the documents which are already in the process, and parties would be given the opportunity to comment on each other's positions and explain where their submissions are really derived from. This would allow for a less formal hearing and potentially one that is more time efficient. And in addition to a sort of topic-based hearing, the applicant submits that it would be beneficial to have, if there were to be further submissions on some of the legal aspects, such as ECHR, it would be most beneficial to do that part by written submissions rather than have a hearing on those topics.
There's a lot going for that because, as I've said, legal submissions I would not arbitrate on. They would be passed on to ministers. So there is a lot to be said for that suggestion. Right, so you envisage that in a hearing, peace would break out, an agreement would be reached. Do you, Ms. McLean?
We hope that a lot of the engineering-based principles could be discussed and agreed, because they are technical matters which the engineers should be able to reach a technical solution between them, which is based across publicly available guidance and standards.
Right. Well, the question arises, Does that have to be in a hearing at all? Do I have to be in the room? I mean, I haven't so far reached agreement, and you know, many years of experience with this. I agree with you. Engineers usually genuinely want to reach agreement. It's a thing they have, but they haven't yet. Mind you, I have, as I say, we could try it. Put it that way, we could try it, but I think I'd want to put quite a lot of effort from both parties into additional preparatory statements for the topic. I think that might be necessary. And you know, I'd be awfully disappointed if your hopes were not borne out, Miss McLean. I can see where you're coming from on that. Mr. Hamilton, sorry, Miss McLean, did you have anything to add? Had you finished?
No, that was pretty much it. Thank you.
Okay, right. Mr. McLean, what do you think about the procedure? What do you think would be best?
Thank you, ma'am. I agree that legal matters can be dealt with by way of written submission, particularly the Human Rights Convention. Otherwise, I think Mr. Brown may have emailed your case officer on Friday to indicate that parties were agreed hearing sessions would be their preferred way forwards.
All right. Was the email that came in on Friday, which I have? I want to talk about that in a minute too, but coming up. Bear with me a moment. Was this the email I've seen? Is one from Mr. MacLeod? Oh no, that's.
I'm getting names.
Sorry.
Pardon.
So is that the one? Is that the email you were meaning? The one from Shepherd and Wedderburn at Mr. MacLeod?
It was 14:28 on Friday, 14th of June.
Yes. So this is the one you were referring to. I'm sorry, I did interrupt you, Mr. McLean. Please carry on.
So I was saying that written submissions on legal issues, I think would be correct. Parties were agreed that hearing sessions would be the best way forward. I think hearing sessions can be adaptable in their intensity of review, if I can put it that way. And although it wasn't discussed between parties, in my submission, an element of direct questioning during the hearing sessions would be a better way to proceed than a full-blown public inquiry format, and more likely to get to the heart of the issues in the most efficient time possible. Thinking out loud based on your comments, ma'am, on written statements for preparation, it may be that some sort of topic paper or the like could be produced by parties in advance of the hearing sessions.
Right.
But I've not had a chance to speak with my clients about that, but perhaps that is a possibility. So that's the position from the landowners. Hearing sessions, I think, are the preferred format.
Okay. All right. Well, you sound like you're a little bit of my mind, Mr. McLean. As you say, hearing sessions are quite adaptable, but I think you might be able to address my Rumsfeld problem by topic papers is, again, quite a helpful idea. Okay. All right. Well, a certain amount of mutual cooperation will be required, but I think I'm probably convinced that I don't need to set up a public inquiry. Put it that way. And I said whether brief written recognitions lodged in advance of oral sessions from the witnesses would be helpful. And I think Mr. McLean called them topic papers. I think that's what we'll do. We'll call them topic papers. And And again, Mr. McLean, as you say, they are adaptable. And if I do find that Ms. McLean's aspirations for agreement between engineers are not being borne out, I could set you on each other. Okay. So moving on now to scope for joint statements of agreed facts and matters which could potentially be included in these. I had thought of national policy. Looking at your papers, it seems to me that both of you are deriving an element of support from national policy rather than, certainly slightly different sections of it. I wondered if perhaps there was a scope for a joint statement on national policy for ministers' benefit. The applicants have done as they frequently do, have outlined in some detail their position in statutory terms, and I wouldn't have thought that as I understand their position, the landowners wish to contest any of that. Your concern is how they've been deployed, not really what they contain, and it might be tidy if the applicants put all that material into a statement. The other thing that this is actually something I think I came up with a bit later. If you remember, this is not a yes or no situation. Ministers are entitled to impose a Wayleave that includes various terms and conditions, and I've rarely seen a case in which terms and conditions might be more sensitive. The applicants have tabled a suggested form of Wayleave. I think it would be a much more satisfactory solution if my report were to include, obviously on a contingent basis, the terms of a Wayleave that had been agreed between the parties. Now, that's, I think I would call that an interesting proposition, an interesting thought. Because, I mean, I can see that you know, whether you, if ministers do reach a position whereby they decide to grant the Wayleave, there will be consequences of that are quite detailed, and it seems to me that ministers might, and I would certainly be inclined, were this to be my view, that ministers might want to wish the parties to agree subsequently to the terms of a Wayleave. But I did wonder whether you wanted to get one done right at the very outset and include it in your inquiry material. Is that something you actually want to think about?
If it would be helpful to you, ma'am, the applicant would be content to attempt to reach agreement on the terms, and perhaps that could be set out in a form in which conditions are ordinarily dealt with in other types of inquiries, where the condition would be either agreed between the parties or the areas of disagreement could be highlighted for consideration.
Okay. Mr. Hamilton, any thoughts on that idea?
Yes, ma'am. In principle, we're happy to work with the applicant on draft conditions that might be applied. Obviously, that's without prejudice to our primary position.
Of course, of course. It just struck me, it might be, I mean, with all the technical dialogue that we must necessarily engage in, you know, it might be a good time. But whatever you think, it is something that I must leave with both parties. I would find it helpful if you were able to develop what you consider to be the right Wayleave if one was to be granted. Suggestions from parties. You've both given me a helpful suggestion that any legal submissions, which we know you wish to make, Mr. Hamilton, were to be in written submissions. But does anybody have any other suggestions about things that could be in a joint statement? Anybody got any other suggestions?
As mentioned before, ma'am, the applicant would suggest that the need for the line could be a matter of agreement between the parties.
You weren't averse to that, Mr. Hamilton?
No, that's correct, ma'am.
Right. Anything you want, the more you can agree on, the better, obviously. So,
I think the other issue which might be capable of agreement is the planning history of the site.
That's an extremely good suggestion, and will be very interesting, of course. Yeah, good. That's a good suggestion. Timescales. We'll circle back round to timescales. In fact, leave timescales with me on joint statements. They're always very difficult to fit into any workflow, in my experience. And they need a lot of effort, and they're often not concluded till late in the day. At the same time, I need to know what areas I don't need to cover. So I'm thinking that once we finally get sorted out for when the hearings will be, the deadline for joint statements will be maybe a couple of weeks before the hearing. But leave that with me. Okay. Just clarification. The energy hub, the Kincardine energy hub. Am I right in thinking that that's not a development that's in any way contested by the landowner? The other bits of infrastructure that are nearby, the one that, no. Well, maybe I can leave that with you too. That's certainly my impression. Good. Right. Moving on to my item 8, which is the arrangements for the hearings. Now, the hearing sessions to be virtual rather than in person. Mr. MacLeod has said he thinks it should be in person. Now, presenting me with a difficulty, because I'm going to consult with the office about that, and I'm going to decide in due course what I think is best here, after I've reflected on what we've said today. But the DPA default position is broadly, excuse me, that the pandemic months demonstrated that both inquiries and hearings can be held quite effectively online, particularly when the parties have experienced professional representation. And they can also be webcast, which again, experience has shown greatly increases public accessibility, and the public resources savings, both in cost and staff time for virtual procedure, are extremely significant. So our default position is that unless there's anybody who'd be significantly disadvantaged by not having the process in person, which is usually unrepresented members of the public, all our oral proceedings should take place virtually. Now, they're not necessarily any easier virtually, but it has many the advantages I've outlined. Now, it was Shepherd and Wedderburn who said they should be in person. What was your thinking on that, Miss McLean?
There is a couple of reasons for requesting an in-person procedure. And firstly, given the number of experts involved in discussions, we feel it would be more conducive of agreement being reached and productive discussion between the parties if all parties were gathered in one place and had the opportunity to speak to face. There's also a benefit to parties participating in what is quite an intense process to be in person if a hearing may go on for more than a day, which in this case I think is possible. And we'll no doubt come on to the duration, but we felt concentration in a virtual setting is very difficult if matter runs on for more than a couple of hours. And the team have contacted a number of venues in the local area and identified 7 suitable venues in the broader vicinity of the site, details of which could be shared with the case officer. And now it was difficult to confirm availability with the lack of dates being firmed up, but there is in principle availability of venues who do have openings in their calendar for the number of participants who could be present.
Well, that's extremely helpful of you, Miss McLean. I don't think I've actually come across that before. The case officer will be intrigued at that. Of course, you can't ask a venue whether they've got space until you know what date you're heading for. And I did think that there are quite a few places along that stretch of the Forth. In fact, I've used a few of them. Severn's quite good. We usually have more trouble than that. Okay, well, that's useful, and it's not that I can definitely see where you're coming from. So I'll see what I decide about that, and I'll also take views of the DPA about it. But Mr. Hamilton, what do you think? Do you think this should be in person or virtual? What do you think?
Yes, the landowner agrees that the substantive hearing should be in person. And the reason for that is, much as Ms. McLean has outlined, when there is detailed evidence to be taken, particularly technical evidence, the flow of that is usually much better in person rather than online. And so the landowner's position is that it should be in person.
Yeah. So much easier to cluster around a plan on a table, isn't it? Let's face it. Right. Well, bear with me a moment. All right. Okay. I will take that back to my management and have a discussion. I can see where you're both coming from. I'd say I was sympathetically inclined, put it that way. Right. Now, supplementary materials I have on my agenda, precognitions, additional documents and deadlines. If we're going to go for topic papers, I'll think about that and I'll issue a direction on that when I do my note of this meeting. I'm assuming that as you zone in on my topics, you may well discover that you would want at least some additional documents. So I'm not going to stand in the way of that, but I will give you a deadline for that. Anticipated duration of hearing sessions. I thought this might take between 4 and 5 days if it was virtual. If everybody's going to be just as keen to minimise disruption as you're suggesting, I suppose we could do it in a couple of days. I think I'll plan for 4/5. Anyone violently disagree?
I think, well, we're content that 4 or 5 are reserved. Certainly, the landowner's position is that 2 days should be more than enough. It may be that, skipping ahead slightly, perhaps day 1 could be used as a site visit day, and then days 2 and 3 as the hearing day.
Yeah. I'm come back to site visits. I'm not sure what I'm going to do about site visits at the moment, but I hesitate to include the site visit exercise in my hearing days. And Mr. Hamilton, I think I'll stick that to the wall just now. Now, let's talk about dates. Mr. MacLeod's email tells me the two pieces of communication which I had in mind when I reached the suggested date. One was an email from Ms. Cannon sent way back in April where she asks for the avoidance of dates in July and in August. And then Mr. MacLeod writes to tell me that there's somebody that you're involved in another compulsory purchase matter, and that somebody's retiring. Am I right about that? I think I've missed out that section in my print, but somebody crucial to the applicant's case is retiring. Is that right?
That's correct, ma'am.
Mm.
And although arrangements could be put in place, it would be far preferable, if possible, to keep the dates before that person's planned departure.
Well, it's a good reason, but of course, I'm assuming that you'll be replacing that person. And I'm sorry, but I really can't do the hearing before the end of July. It is impossible for me. Now, what do we do? I can't give you what you're requesting, Ms. McLean. I can't give you a date before the end of July.
In which case, the applicant will make arrangements as necessary, but an earlier date would be far preferable if possible.
Why would an earlier date be preferable?
Well, without straying too far into the topics, but it's linked to the construction timetable and when works need to commence on site.
Yes, I can just imagine that would be a concern, but I think that at the moment it is extremely difficult to instill that degree of certainty into this process. If you think about it, my report has to be completed, then ministers have to consider it. And I assume that the thinking you're bringing to this is that every second counts. But one still has to ensure that matters proceed in an orderly fashion. The date that I'm suggesting in September is not brilliant for me. I've inserted this proceeding in amongst other work, so it's not the optimum time for me, but it's sort of chosen in the knowledge that you would wish to proceed, and also with regard to our target date. It is my intention to meet the DPA target date for the report. Mr. Hamilton, I chose the date with regard to Ms. Cannon's email, so I hope it suits you.
Yes, ma'am. Thank you. It's the week of the 2nd September does suit us, and the landowner believes that strikes the appropriate balance between efficient disposal and effective preparation for the hearing.
Right. Okay. All right. Okay. Well, sorry, Ms. McLean.
Would you be minded to consider the dates in August, and perhaps if there's additional submissions to be made, then perhaps the second set of dates in August, which allows for 3 days to be reserved?
How do you mean the second dates that's suggested in
Mr. MacLeod's email, which is the 19th to 22nd of August, which I understand suits the landowner's team?
It really doesn't suit me, Ms. McLean. That'd be when my other matter is under consideration. So I don't think I can do that either. I mean, it was helpful of Ms. Cannon to give us that degree of notice. So I've worked my own work programme around that in order to try to accommodate yourselves, but there will be other impacts. So I'm afraid I can't give you August either. Sorry, never mind. 5th of September isn't bad. It isn't bad. And as I say, it's not ideal for me. And as I also say, it would be my intention to meet the deadline, but I couldn't have. I'm very unlikely to have been able to do it any earlier than our target date. Okay, so under mild protest, Ms. McLean, the 5th of September you can work with. What else was there now? Bear with me a moment.
Can I note one further matter on dates and availability? The applicant in this case is involved in, as you've quite rightly noted, in a compulsory acquisition process for which a pre-examination meeting is set on Monday next week.
Right. Sorry to interrupt, but could you give me the case reference for that?
It's CPO 150-2.
Do you know who the reporter is?
It's Elspeth Cook.
All right. Okay. Sorry, I interrupted you. What were you going to say?
I was hoping to suggest that the applicant's team would update your case officer on the potential dates which are being considered for that process, just to allow you, if you were minded to do that, to take that into consideration when setting the dates.
Well, there's definitely some scope for fine tuning this. I think my own work program is probably going to be the major obstacle. September is the best, is the least bad time for me. But there's every piece of scope for the two case officers, and indeed, if necessary, me and Ms. Cook to liaise about the logistics of dates. That's definitely a possibility. Okay. Yeah, site visits. Now, I'm looking forward to seeing Kincardine for a power station. I wondered what else you wanted me to see. I think that I had thought I usually like to inspect a site early on in the process. In this one, I thought I'd wait until I knew more. So I was thinking about a site visit after hearing the evidence rather than before. Do you think, is there a strong reason for me to go prior to hearing the evidence? Ms. McLean?
The applicants would suggest that it would be more beneficial for a site visit after the main sessions have taken place. And as you say, at that point, all the parties will have explained their evidence and be able to point to certain elements of the site which had been discussed in evidence, just to bring it to life rather than visiting the site in advance, in which case a lot of it might be slightly in the abstract.
Yeah, and I think I'd have to go back, to be honest. Mr. Hamilton, your views? Is it okay for me to go after the evidence?
Certainly for you to go after the evidence, ma'am, but we'd suggest also a visit beforehand. I think particularly where there are a number of alternative routes, as you will have seen, that's one of the key issues, ma'am. Getting a kind of broad understanding of where they fit in would be best achieved by a site visit beforehand, and then, of course, a site visit after.
Mm-hmm. Right. Okay. I'll mull that over. It is an attractive suggestion, and I mean, this is a complex matter. You know, 2 site visits happens all the time. I'll think about that. I think. I think this will be one where concluding submissions will be required for my benefit, certainly, but I would anticipate that concluding submissions would form part of the materials that are passed to ministers. So I would expect to be ordering those towards the end of the process, and you probably won't have long to conclude them. I think that's all the matters I wanted to touch on under my agenda item 8, arrangements. Does anybody have any other matters under item 8 or move to any other miscellanea? Anything else about logistics? Okay, right. Okay, I'll be getting my case officer to. I would like you to send my case officer your 7 venues, Miss McLean. Send them to her. Right. So I think that takes us to item 9. Any other competent business? So does anybody have anything else they wish to raise this morning, Miss McLean?
Nothing further for the applicant. Thank you, ma'am.
Okay, Mr. Hamilton.
Landowner.
Sorry.
Sorry, nothing for the landowner, ma'am.
Okay. All right. Well, I think my impression is that you have shared my degree of puzzlement about how I work this one out. And I think we've reached a bit of a consensus there, and I'm very much obliged to you for your ideas on this. I was worried about having too many hybrids, what on earth are we doing here? I'll try and make sure that my arrangements as were laid out are absolutely clear so that everybody, including the non-legal persons, feel that they know what's going on. But I think we are going to be doing a bit of a hybrid. But, it seems to me like you hope that this might be some form of an agreement reaching process. Well, it would be good if agreement could be reached on something like this. However, we are where we are. So, and if nobody has anything else to add, what will happen next is that I will think about what we've discussed, very much assisted by your comments, and I will produce a note. It might take me a few days to do that. I have a little bit of 1 or 2 consultations to do internally before I finalise that. But I would hope to issue it by the end of this week, and I will certainly do it as soon as possible. And if it's earlier, I'll try and do that. If I can make it earlier, I will try and do that. But that being said, I think that's us for this morning. And thank you for your participation and for your preparation. And I'll close the meeting. Thank you, everybody.
Thank you, ma'am.
Thank you.
Thank you, ma'am.
Thank you.